association legal, any legal issues affecting your organizations, things that you're dealing with now, things that you've done with in the past, things that you've wondered about. It can be more specific or it can be more general. Sometimes if you ask me a specific question, I will take a few minutes, maybe 5 minutes, to give you a little background on kind of the legal kind of construct and kind of backdrop that you need to understand in order to analyze and answer your question, just to make sure that you have the proper context to be able to understand the issues. Pretty much everything is fair game. Any issues that you want to ask about, from federal tax exemption and unrelated business income tax to contracts, corporate governance, bylaws, conflicts of interest, contracts, meetings and conferences, copyright and trademark issues, employment issues, regulation of lobbying and political activity. Pretty much anything under the sun is fair game. And this is going to be driven by your questions, and we'll go for as long as you guys have questions, I think for about 45 minutes today. I did get a couple questions in advance from some of you. And actually, why don't I just start with those while you guys kind of get your brains going and start thinking of other things that you want to ask me about. So first off, one question that I received is if a 501c6 tax-exempt association invests reserves into treasury bills, is the interest it earns subject to unrelated business income tax, or UBIT? And are there any?
I made it. Yeah.
And are there any thresholds for taxation that associations need to be aware of? So let me kind of take a step back first off. And I'm actually going to put something in the chat that would be useful to you, I believe. This is an article of mine that was published in several places. This one's from the American Bar Association, one of their magazines. Let me just post this in the chat. And so on our firm's website, which is tenenbaumlegal.com, we have a wealth of resources, articles, presentations, and recorded webinars on a really broad array of different association and nonprofit legal issues. This one is on our website as well. If you go to the resources tab, you'll see all of those different subtabs for publications and webinar recordings and whatnot under there on tons and tons of different association legal issues. So feel free. We're constantly adding to that as well. So feel free to go there anytime you're looking for resources, or feel free to email me if you have questions. My contact information is on the site as well. And so what I just sent you is a link to an article about unrelated business income tax for nonprofits. It's a good overview article of kind of UBIT, as we call it, unrelated business income tax in general. And it does kind of a deeper dive into kind of three typically hot button areas for associations: royalties or endorsement income, corporate sponsorship income, and qualified convention and trade show income. But as the article points out, tax-exempt organizations, including 501c6 associations, same rules apply to C3s and other categories of exempt organizations. When you earn income from activities that are substantially related to your mission and purpose, all of that income is considered what's called related income. It's related to your mission and purpose, and therefore it is exempt from federal and state corporate income tax. It's one of the primary benefits of being a tax-exempt organization. So think things like membership dues and conference registration fees and publication sales, or if you had certification or accreditation programs for a C6, all of these things are substantially related to the mission and purpose, and so they generate tax-free related income. If you collect special assessments or contributions for lobbying activities or other things like that, that's all related income. But since 1950, there's been these provisions in the tax code that say, if you engage in regularly carried on business activities that are not substantially related to your mission and your purposes, the most notable one for associations being advertising, then you are taxed on the net income. So net, meaning gross revenue less any directly connected expenses that you incurred to generate the income. Your tax, that net income is subject to the unrelated business income tax, which is at the standard 21% flat corporate income tax rate. And that tax is levied. That's the federal rate that you're assessed on. And then if your state has a state corporate income tax, you're assessed at the state level as well. You can earn unrelated business income. It's not a bad thing. You do obviously have to pay tax on the net income, but then there's a limitation that you can't earn too much of it. If you earn too much unrelated business income, you can put your tax exempt status at risk. Generally, most nonprofit tax experts will peg that at about 15 to 20% of total income. So if your gross unrelated business income starts to approximate 15 to 20% of your total gross annual income, that's when you could be putting your tax exempt status at risk. And that's when you would want to consider forming a taxable subsidiary. I'm going to give you an article on that as well, because actually that's the other question I got in advance was about taxable subsidiaries. Let me post this real quickly in the chat. There we go. So if you run into that very fortunate situation when you stumble on some unrelated business activity that's really profitable and starts to generate a ton of revenue, don't get worried that you're going to put your exempt status at risk. Just form a wholly owned taxable subsidiary, drop the activity or activities into that subsidiary, and carry it out then on an unlimited basis. And the nice thing about taxable subsidiaries is that, of course, they're paying tax on the net income like any for-profit corporation would, but then after-tax profits can all be paid to the parent association or nonprofit organization in the form of dividends, which are tax-free to the parent on an unlimited basis. Now, all of that was the background. I told you I would give you a little bit of background for some of these. So to answer the questioner specific question about interest from T-bills, so unrelated business income tax, again, things are substantially related to your mission and purpose are going to be related income. If you engage in regularly carried on business activities, so not a one-off thing, but regularly carried on business activities that are not substantially related to your mission and purpose, that generates taxable unrelated business income. However, there are numerous exceptions and exclusions built into the tax code for various types of income and activities. And if you can fit the income into one of those exclusions or exceptions, that's going to be exempt from UBIT. And one of those is for interest and dividends and annuities, generally referred to as passive income. Basically, anytime you're like investing your money and then, it's earning some interest or annuities or dividends or capital gains, but you're not actively, you're just investing it, someone else is using your money and then you're getting some earnings off that. All that is considered tax-free. It's one of the exceptions to unrelated business income. So interest in T-bills is all tax-free. You can earn it on an unlimited basis. The questioner had asked if there's any thresholds, and no, it's on an unlimited basis. Other common exceptions, 3 of them are discussed in that article I just sent you a link to. Royalties, when you let someone else use your intellectual property and get paid for it, like an endorsement or affinity type situation where some company says, we want you to endorse our company's product or service to your members, on an exclusive basis. So, we're going to pay you whatever 2% of the sales of our product or service to your members for the next year in exchange for you licensing your logo to us to let us use that to promote the sale of the product or service to our members. If you do that, that is generally going to generate tax-free royalty income. You can earn it on an unlimited basis. The thing that the article talks about, though, is if you engage also, in addition to the licensing of your mark or whatnot, like logo to the company, if you also engage in active marketing of the company's product or service to your members or others, engaging in marketing services on behalf of a for-profit company does not qualify for tax-free royalty treatment. It is going to generate taxable unrelated business income. So as the article talks about, you kind of need to bifurcate the income stream so that part of it is royalties for the license of your logo and maybe your membership list or whatnot. And part of it is going to be taxable unrelated business income if you're engaging in marketing services on behalf of the company. Another exception, very common, very important one, is for corporate sponsorship income. That one's the most recent exception. I think it was 1996 that was put into the tax code by Congress, and came about from kind of the college bowl setting where corporate sponsorships are very common. IRS was going to great lengths to try to tax college and universities' corporate sponsorship income, kind of like advertising income. And what Congress did in enacting this corporate sponsorship exception to the unrelated business income tax is it's a construct that says, look, if a sponsor comes along and wants to pay you to sponsor an event, a golf tournament, or even just a general sponsorship on your website or something, they're going to pay you money and you're going to acknowledge that sponsorship. You're going to thank the sponsor. You're going to, put their logo, their contact information, maybe a link to their website, things like that. What the rules say is that as long as you're just doing that and you're just acknowledging the sponsor's contribution to your organization, that's going to be tax-free corporate sponsorship income. But the IRS came out with some very specific regulations that say, in order to constitute a mere acknowledgement, you can do things like use a sponsor's logo, even use an established slogan that the sponsor uses. You can have a non-qualitative description of the company's product or services. You can have contact information, a link to their website. But what you can't do is have any qualitative language about the company's product or services. You can't have any endorsement type language. You cannot include any pricing information about the company's product or services. Certain things like that will turn at least some of that income into taxable unrelated business income in most situations. So again, a really important exception. And if you understand it, you can often take what would otherwise likely be taxable unrelated business income and turn it into tax-free corporate sponsorship income. One caveat is that the corporate sponsorship exception is not available for sponsorships in periodicals like magazines or newsletters. So you can't use it to turn advertising in your magazine or newsletter into tax-free corporate sponsorship income. And then the third big one that's talked about in the article is been in the tax code for many years, I think since 1976. And that's the one for qualified convention and trade show revenue. Educational conferences, things like that, that's generally going to be considered a related activity. But where this exception is most important is when it comes to trade show exhibit fees. So if you have exhibitors exhibiting at your conferences or trade shows, and they pay fees, the IRS back in the 70s was trying to tax that income as unrelated business income, saying it was akin to advertising. And thanks to some lobbying by ASAE, Congress stepped in and passed this exception. So now all of your trade show income is exempt under that exemption. So all of that is background to give you kind of, I've given several hour, presentations about association taxation and unrelated business income. That's kind of a 10-minute version in a nutshell, and it answers that first question. The second question I got in advance was if an association creates a wholly owned subsidiary, and I think the questioner means a wholly owned taxable subsidiary, because if it's a nonprofit corporation, it has no owners by definition. Only for-profit corporations have owners. So if it's a wholly owned subsidiary, presumably it's a wholly owned taxable subsidiary, like I just talked about, sent you that article about it. And the question is it customary or not for that wholly owned subsidiary to have its own bylaws or policies or procedures adequate? So, now we're veering off from federal tax code, federal tax exemption issues into nonprofit corporate law. So before I answer that question, let me just give you a little bit of background. There's an article on our website, another one called something like, what's the difference between nonprofit and tax exempt status? And that's exactly what it's called. I'm going to post a link to that one as well. And what the article talks about is that a lot of people get confused all the time. I was just reading an article yesterday in the Washington Post that talked about, an organization's putting its nonprofit status at risk, and this was due to some potential tax code violations. That's an incorrect statement for the most part, because nonprofit status, tax exempt status are two very different things, and it's important to understand the difference, including to answer this question. So the nonprofit status is a status that comes from incorporating as a nonprofit corporation. So all of your associations, and you're all, for the most part, I think, state associations, presumably you're incorporated in your state. Every state has a Nonprofit Corporation Act or statute. Most of them are modeled after the American Bar Association's Model Nonprofit Corporation Act. A lot of them are substantially similar. They all have some differences. Some states like New York and California are very different. Delaware's is also very different, but most of them are fairly similar. And they govern the operations of nonprofit corporations. So you first incorporate in a state by filing articles of incorporation. Then you would go to the IRS and get an EIN number. And then you have to follow the requirements of the nonprofit corporate statute, one of which is that you have to have bylaws. So to answer that specific question, if you have a wholly owned taxable subsidiary, it doesn't matter whether it's wholly owned or not. If it's a corporation, frankly, whether it's a nonprofit corporation or a for-profit corporation, it has to have bylaws. In a different type of a for-profit, an LLC, a limited liability company, the functional equivalent is called an operating agreement. It's the functional equivalent, but an operating agreement is significantly different than bylaws. But bylaws are kind of the principal governance framework for the organization. They determine, who runs the organization. If you have members, what's the role of the members versus the board, versus officers, versus committees. All of those things get kind of parsed out in the bylaws. Bylaws have to be consistent with the State Nonprofit Corporation Act. So for instance, most state nonprofit corporation statutes say that while members can vote by proxy, like for membership voting, board members cannot vote by proxy. Boards in most states can only take action two ways. Texas is a notable exception, but in most states, boards can only take action through a duly constituted meeting, meaning you have proper notice, you have a quorum, and then you take votes at a meeting. And for most votes, a majority of those voting, majority of a quorum is going to carry the day. That's one way to take action. Doesn't have to be unanimous. Meetings can be in person, they can be virtual, they can be hybrid. They all count as a meeting as long as everyone can hear each other at the same time. That's one way a board can take an action. The only other way in most states is through what's called unanimous written consent, where basically all board members vote in writing. It can be electronic now in every state, but it has to be unanimous. So they all have to vote the same way. If you had a provision in your bylaws that said, board members can vote by proxy if they can't attend a meeting, or board members can send a substitute in their place from their same organization if they can't attend. Those two things are prohibited by most state nonprofit corporation statutes. And so if your bylaws said that, those provisions would be invalid. And so it's always important to make sure, and I get this question a lot, how often should we have our bylaws reviewed? And one of the things you're reviewing them for is compliance with the state nonprofit corporation statutes. Those statutes change, by the way, on a somewhat regular basis. The American Bar Association just last year put out the 4th edition of the Model Nonprofit Corporation Act. And as such, a lot of states now are looking at their own state nonprofit corporation statutes and enacting changes to comport with what the ABA recommends. And they're generally very helpful changes. They are very helpful changes. I serve on the committee that kind of oversees that process for the ABA. But it's important, maybe every 5 years or so to review your bylaws to make sure they're fully compliant with the state nonprofit corporation statute, to make sure that they're not overly burdensome, that they're not getting in the way of effective, efficient governance, healthy governance, that, they actually match up to the way you truly operate and practice. All of those sorts of things are really important. And actually, well, no, I don't have it on the website, but I do have an article about association bylaws that talks about all of those sorts of issues. And so bottom line is, the question is, the question was, do we have to have bylaws if we have a wholly owned subsidiary, taxable subsidiary? The answer is yes, because the state nonprofit corporation statute requires it, and the bylaws have to be consistent with what's in the statute. And then finally, the policies and procedures, also very important. So one thing I do a lot of like association board trainings on like governance and legal issues, legal duties, fiduciary duties, and things like that. But one of the things that I always talk about in those trainings is the hierarchy of documents from a governance perspective. And each one in that hierarchy has to be consistent with what's above. So at the top, you got the state nonprofit corporation statute. Beneath that, you have the articles of incorporation, which is the document that was filed in your state to create your organization. Usually a fairly bare bones document. One important time it gets amended is if you change your name at all. You have to amend the articles of incorporation to change the name. Otherwise, usually most nonprofits don't change their articles of incorporation much over time. But beneath that, you have the bylaws, which are the principal governance framework for the organization. And then underneath that are policies and procedures. And so you need to make sure your policies and procedures are also consistent with your bylaws, your articles, and the state nonprofit corporation statute. And one thing that we do, we review bylaws literally every week for different associations and nonprofits. And one of the things that we often find ourselves doing is recommending that certain provisions in the bylaws be pulled out and put into policies and procedures, because it's generally best practice. You don't want the bylaws to be too long and cumbersome, too detailed, especially if your bylaws require a membership vote to be amended, which is often the case, not required by law, but often the case in many associations with voting members. Because of that, whereas policies and procedures generally can always be amended by the board alone, you don't want to make it too difficult to have to change things all the time by constantly going out for membership votes. And so that's an important reason to try to put as much of the detail as possible into policies and procedures, and don't clog up your bylaws with too much detail. And you certainly don't want to be in a position where you're having to amend your bylaws every year. So that was 2 long answers to 2 important questions, but because they covered both federal tax exemption issues and kind of corporate governance issues for associations, I thought it was important to give you that background. So why don't I stop there, take a sip of coffee, and see what questions you guys, what other questions you have.
Great input. Just a reminder for all of you who do have questions, if you could please raise your hand, or in the chat, let us know you wish to speak so we don't miss you. And if you're not able to find the reactions button at the bottom to raise your hands, you're welcome to unmute your mic and we can take it one-on-one. All right, we do have a question from Andrew. Nonprofit, want to make sure we can find someone to make the nonprofit for donations for political and education. Not 100% sure what the...
Yeah, Andrew, if you could maybe unmute yourself and ask, put a little more context there. I'm not sure I understand the question.
Okay, so now I unmuted. It's a little easier unmuting. Basically, I know that we're a C3 right now, and therefore I'm under the understanding that it's okay having our lobbyists do the work that way. But if we want to create some kind of donations for lobbying events and stuff like that, you need a C6. That could also go to the donate to the C3 to get things done if we choose to. But I want to make sure that like some of the doctors want to be able to write off their donations. So that's why we're thinking creating the C6. I may have it mixed up, by the way.
No. Okay, now I understand. All right. So, and let me give you guys, I just posted 2 articles of ours, one by me.
Oh,
and
by the
one
way, if you say you can do it, then I don't even care about the question, because then I just go to you.
well, no, I can definitely help you for sure. We do this all the time. But so here's the thing. 501, there's about 30 different categories of tax exempt status. In the association world, C6 and C3 are the most common. Once in a while, we see some C4s, but mainly C6s and C3s. And it's also very common for a C6 to have a related foundation that's a 501c3 organization. And yes, I do have an article on that as well. I just posted that one. So that's all about related foundations of associations. And one of the reasons that a lot of associations have related foundations is because 501c3 is the most beneficial category of tax exempt status, including one of the more notable features of a C3 is the ability to receive tax deductible charitable contributions. So individuals and corporations that donate to a C3 can take a charitable tax deduction for those donations, less the value of anything they get in return. In addition, C3s are eligible for a lot of grants from like private foundations, even other public charities, federal, state, local governments that are often not available to C6s. There's some other benefits as well, tax beneficial ways that people can leave money through their estate planning and their wills to C3s. Lots of benefits, but C3s also have the most restrictions on their activities. The two, one of them is the private benefit doctrine, which I'm not going to get into here unless you wanted to hear more about it. But two of the more notable ones in the association world are the fact that C3s are banned from engaging in any political campaign activity. That means supporting or opposing candidates for public office, complete ban. Theoretically, even the smallest amount of political campaign activity, like making a PAC contribution or endorsing a candidate or giving a candidate a platform to promote his or her reelection or anything like that, strictly prohibited for C3s. C3s are also limited in the amount of lobbying that they can engage in, but it's not prohibited. So C3s can engage in lobbying. As the two articles I sent you links to talk about, there are two different rules, two different sets of rules and guidelines that govern C3 lobbying. One is the default rule called the no substantial part test. The other is the more, especially for smaller associations and certainly for all of your associations, you want to make what's called the 501H election. It's a super easy half-page form that you file with the IRS online. You'll see the form number, and I think even a link to it in one of the articles. Once you make the 501H election, from that point forward, you're going to be governed by this much more favorable set of lobbying rules and definitions and limitations and whatnot. There's a lot more clarity. There's a lot more things carved out from the definition of lobbying. Things like regulatory and executive branch lobbying don't count as lobbying if you make the 501H election. Volunteer efforts toward lobbying don't count as lobbying. Only things that you pay money for, like staff or outside lobbyists, or maybe if you're paying travel expenses for volunteers, but volunteer time doesn't have to get counted. There's exceptions for educating legislators and other things, none of which exist if you don't make the election. And then there's very specific numeric limits on how much lobbying you can do each year. It's kind of a formula based on the organization's size. The articles talk about that. Make the 501H election, even if you engage in the smallest amount of lobbying, it's going to be much more beneficial. And then you can engage in lobbying just up to certain limits. Now, that being said, sometimes associations want to engage in more lobbying than is allowed by the limits, because the limits roughly comes to maybe 20% of your total budget each year can be spent on lobbying. But if you wanted to spend more than that, and or if you want to engage in political campaign activity, like supporting state candidates for public office or things like that, if you're a state that allows for corporate PAC contributions, things like that, you can't do that through a C3. So then you would have to create an affiliated either C6 or C4 organization, which are allowed to engage in those activities as long as it doesn't constitute more than half of their overall. They can engage in political campaign activities as long as it doesn't constitute more than half of their overall activity. And so it's very common, sometimes the C6 is kind of the main entity and then create a C3 to take advantage of those benefits. Sometimes, like in your case, Andrew, the C3 is a primary entity, then you might create a C6 or a C4 to engage in some of these other activities. And then you just have to be very careful, and I work with clients all the time on this, to make sure that you're kind of using the two entities in the right ways. And really importantly, as the article about related foundations points out, you can't have the C3 in any way subsidize the C6 or a C4. You can have the C6 subsidize the C3. So the C6 is your main entity and you create the related foundation, you can have all of the staff of the C6, just donate services to the C3. And that's all fine and good. Donate, office space, overhead, all of that kind of stuff. But if it's the flip side, like in your case, Andrew, where the C3 is the main entity, you have to make sure you track all of that time, all of those expenses, and then the C6 will have to reimburse the C3 for the cost of all of that time, the cost or value of all of that time. So again, that's a whole nother rabbit hole. I could go down and talk all afternoon about those issues, but I think that gives you an overview there. Hopefully that answers your question. Those articles will give you more detail. So I see we have a question from Dawn. California State Association files a group income tax return for all of its districts and chapters. They all have their own federal EIN numbers. They also have bylaws. Getting financial information from them for the tax return is a struggle. Are these districts and chapters still considered standalone nonprofits with the same requirements as the parent C6? Or does the state association have a greater degree of responsibility? Great question. So one thing that I don't know, but I'm going to presume, Dawn, is that there's what's called a group exemption in place. So a group exemption or a group tax exemption is a feature that, believe it or not, some associations don't know about, but whether it's a national association that has state chapters, state and local chapters, or whether it's a state association like yours that has its own local chapters or districts, whatever you want to call them. So this isn't a situation where each of those chapters is a separate legal entity. It's not common, but for some of our clients, they have chapters where they're not separate legal entities. They're all just part of the main organization. You could think of it as like a division or a local office, of the same organization. It's all one common EIN number. The EIN is like a corporate social security number. That's the number one way to tell whether it's a separate legal entity. Because if they all have separate EIN numbers, it means by definition they're separate legal entities. But because it's a bit of a pain in the neck for especially smaller chapters to obtain their own recognition of federal tax exempt status, the IRS has this group exemption process where the parent entity, what the IRS calls the central organization, can apply for and obtain a group exemption for all of its what are called subordinates. That's what the IRS calls them, but it's basically the in your case, the local chapters. Those are all the subordinates. And if they all, basic requirement, there's a few more details. You can see this, there's really good resources on the IRS website. If you just go to irs.gov and type in group exemption, you'll see all the details there. But if you're a state association that has local chapters, but you're not sure whether they're tax exempt or whether they filed their own exemption applications, take a look at a group exemption. I'm presuming that's what you have in place. And then in a group exemption, as long as all the subordinates they've adopted a common set of bylaws and they share the same tax exempt status as the parent, then they can all be subject to the group exemption. And yes, you are essentially attesting to the IRS. Each year you have to file a letter with the IRS listing all of the members of the group exemption, whether any have been added or whether any have dropped off. You list their names and their EIN numbers, and then you're basically attesting that, yes, we believe they are complying with the rules for federal tax exempt status. But separate and apart from that, this is what a lot of people don't realize, is that there is an IRS Form 990 filing requirement for every tax exempt organization. And even if you're subject to a group exemption, you're still subject to an IRS filing requirement. And if you fail to file an IRS Form 990 for 3 years in a row, you get your tax exempt status automatically revoked. And if that happens, the only way to get it back is to file a new tax exemption application with the IRS. You can't, for instance, rejoin a group exemption to do it. And there's 3 different types of the Form 990, depending on the size of the organization. There's the regular Form 990, the Form 990 EZ, and then the Form 990N, with each of those succeeding ones being shorter and simpler to follow. The 990N is super simple. So it all depends on I think it's the annual revenues of the organization. That's what dictates which form you file. But it's really important if you have local chapters to make sure that they are filing their Form 990, whatever version, with the IRS each year. Now, the one thing it's very unusual, is what's called a group return. It's a group Form 990. Now, if you have a group exemption, it doesn't mean you have to do a group return. And most associations that have group exemptions don't do group returns for the same reason you just said. Pardon my language, but it's a pain in the ass because you got to get all of that financial information from all of the chapters, the subordinates, to include it in the group return. The group return, by the way, it's not the same as your own state Form 990. That's separate. This is a separate return that basically aggregates all of the members of the group into one return. It's usually done in situations where these are all just volunteer-run local organizations that are very small, and it's almost too burdensome to ask them to file their own Form 990. And so this group return process is what happens. But it's certainly permissible, not commonly done. It sounds like you guys do it in California. And so, yes, you have to do that, and you have to make sure you collect that information for all of the members of the group each year. So I hope that helps. One other thing to keep in mind that also trips up a lot of small chapters is that in addition to these IRS Form 990 filing requirements, then you also have to file in your state. Most states, in order to be exempt from state corporate income tax, it's pretty much automatic when you have the federal, but you still have to apply for it, and you still have to file a copy of your Form 990 with your state tax office each year. But the other thing that a lot of small chapters get tripped up on is the corporate status. So in most states, to maintain your nonprofit corporate status, remember we talked about that earlier in the session, to maintain the nonprofit corporate status, you have to file an annual report with the state, whatever office it is. Some states it's a Secretary of State, some states it's a state corporation commission, some states it's the Attorney General's office. It varies state by state. But most states say for nonprofit corporations to maintain their corporate status, they have to file an annual report with the state. Sounds onerous. It's not. It's usually like a 2-page form. Pretty much nothing else has changed. Here's our current list of board members. Check a few boxes, pay your small, whatever, $35 annual fee, and file the form. But if you fail to do that after a certain period of time, you will have your corporate status revoked. And then after a certain period of time in most states, your corporation will be what's called administratively dissolved. So you don't want to ever let it get to that point. Most states have a great online database where you can check the corporate name and you can see the status and you can see whether the annual reports have been filed, which have been missing, that sort of thing. Where I'm in DC, it's every other year, what they call biennial process for filing the corporate annual report. But it's really important, like in California, Don, to make sure you're reminding all of your locals about the importance of filing their assuming they're corporations, right? The alternative is that they could be what's called an unincorporated association, which is allowable. And unincorporated associations can be part of a group exemption as well. But it's much more beneficial to be a corporation because main benefit of a corporation is it protects the board and the other people that run the association from personal liability risk. But you're going to lose that corporate status if you don't file the annual report. Let me just
We
go.
do have, Andrea has her hand raised.
Andrea,
well.
please, yeah, pose your
From
question.
Colorado.
Thank you. I just had a question about I think Liz shared the antitrust article from ASAE with the group. I had received that through them. And if I'm wrong, I'm pretty sure I saw it in the listserv thread. But are you familiar with the article that they put out about the recent DOJ information with antitrust laws and how it might throw a wrench in what they've previously advised associations on?
I have not seen that article. What specifically is, I do a lot of association.
So the way, and Liz, I don't know if you're on, I see your name, but I'm not sure if she's sitting at her computer. Maybe you could explain a little bit better. So my understanding after reading it is they've kind of walked back the guidance that they've given associations in the past, and they're dealing with it on a case-by-case basis. But the previous guidance about using aggregated data that was more than a certain period of time old and included more than 5.
Yeah, you're talking about the safe harbor, the DOJ.
Yeah, yes, that's the word. It sounds like that has gone away.
Really?
And Liz, maybe you can speak to that.
That is
Yeah, there's been some changes. They put a notification out, and I can grab that and put it in the chat in just a moment. But basically they changed some of the rules and took some of them back. And we were talking about this because it was like, well, how do we interpret this now? Oh, did Mark found it and threw it in there from ASAE into the chat.
I see it.
Maybe you can take a quick peek at that, see if you've seen it.
Yeah, this is from Pillsbury. Yeah, this is definitely news to me. Looks like just from a couple of weeks ago, and I had not seen this, so I thank you guys. And actually, I was just counseling a client yesterday about this stuff. So yeah, I don't have time to read this and analyze it midstream during this call. I most certainly will. But so let me just explain this issue. So it's very common, and by the way, I posted a link to a recorded webinar that I did maybe a year ago about kind of association information exchanges and benchmarking and how to mitigate the antitrust risks. So it's very common for associations to gather data from usually members, about the industry or the profession, things like salary surveys, compensation surveys, or, you name it. I deal with so many of these in different areas. But because a lot of this data is competitively sensitive, it if certain data is shared with members in a certain way, it could be used to lead to the most serious antitrust violation for associations, which is price fixing. That's when two or more competitors agree on prices to be charged, which is a per se violation under federal and state antitrust laws. And so to avoid risk in this area, my God, it's probably 25 years ago at least, the Department of Justice Antitrust Division and the Federal Trade Commission came out with this joint guidance, creating a safe harbor for how to avoid potential price fixing liability in this area. And it was targeted at the healthcare industry, but they made very clear in the guidance that it applied to all other industries as well. And what it basically said is that, now, it's just a safe harbor. It doesn't mean, like any safe harbor, if you don't comply with the safe harbor, it doesn't mean you violated the antitrust laws. It's just that if you stay within the safe harbor, you know you're safe from any antitrust violations. And the basic requirements are that any data that gets collected, any competitively sensitive data, of course, like prices or compensation or salaries or other things like that, that the data has to be at least 3 months old at the time it's collected. The data has to be aggregated so that you can't identify any individual participants. There has to be, I think, a minimum of 5 participants in each category, and no one participant's data can constitute more than 25% of the total data. And then the data has to be collected by a party, like a third party that's not an industry member. So basically, and they said trade associations are an example of what is permissible. So a trade association staff can collect data, outside consulting firms, there's a number of them that do this on a big scale, they can collect the data, but you can't have any of the members, for instance, be involved in the data collection. And the raw data should never be shared with the members. That's basically the safe harbor. Now, regardless of what DOJ put out, and I'll take a look at it, I can tell you that if you comport with these requirements, it's going to be very hard to violate the antitrust laws and engage in price fixing. Now, it might not provide the same level of protection if DOJ has changed something. I'll have to take a look at it, but it's still going to be a best practice to follow. And I can't envisioning advising clients to do anything differently unless DOJ is planning on like tightening up the safe harbor to make it even more more strict in terms of, saying there has to be at least 10 participants instead of 5 participants or something like that. I have no idea. I will take a look at it, but it's an important issue. I will certainly be keeping a close eye on it. But what I shared with you, and I also have an article, it's not on our website for some reason, but it's an article I wrote in connection with that webinar that kind of talks about the safe harbor, and I'll try to post that here before the end of the webinar. Other questions?
I think Dr. Altman had a follow-up question to the California question. Did you say we have to file within our own state, wondering if creating a 501c3 would be better to form it in another state?
So no, you don't have to incorporate. I mean, most of our clients are national associations, and so they can incorporate anywhere. And even if you're a state association, you don't have to incorporate in your state. It would be unusual to not incorporate in your own state, only because it's a very small issue, but most states say for a nonprofit corporation, when you incorporate, or a for-profit corporation, you have to have a registered agent in that state and a certain requirements for who can qualify as a registered agent. It's like to receive official communications from the state. If someone sues you, where they can deliver what's called service of process, like a process server, and you have to maintain a registered agent. And if you use one of the corporate registered agent services, there's a fee that goes along with that as well. And so if you're in your own state, usually, like, for instance, a board member or an officer or executive director can serve as a registered agent. We actually don't recommend that. We still recommend using one of those corporate services because those individuals change a lot. But if you are incorporated in a different state, like say, I don't know what state you're in, but say you're located and your headquarters is in Arizona, but you incorporate in Colorado, then you have to maintain a registered agent both in Colorado and in Arizona, because if you're incorporated in one state and you're located in another, you're obligated to what's called qualify to do business as a foreign corporation in that other state, basically getting your corporate status recognized And then you have to file an annual report and pay the registered agent each year in that other state. So because of that, it's, for most state associations, they just do everything in one state, but you certainly could, especially for instance, if you're located in California or New York, for instance, which great states, but they have horrible nonprofit corporation statutes. Every nonprofit lawyer recognizes that. I'd probably absolutely recommend incorporating in another state. But I get this question a lot too. Once you're incorporated somewhere, you can't just at whim change your state of incorporation and shift it to another. Some states allow what's called domestication, or some states call it redomestication. But both states have to allow it under their state nonprofit corporation statutes. And if both states do, then you can actually transfer your state of incorporation from one state to another. But if one or both of the states don't allow it, that's not possible. So, sorry, that's a lot of information. We're just about at the top of the hour, but any other questions from anyone?
All right, now's your time. Calling for last questions. Okay, seeing none. I will tell you that Jeff continues to have some amazing resources on his website, and I appreciate all that you are willing to share with us as state association leaders. Certainly that helps us a lot to at least know the questions we need to be asking to our attorneys. Any other comments? And I'm going to turn it over to Liz. Thank you, Jeff. We appreciate you so much. You are one that continues to be asked for within these monthly meetings. So I feel quite reassured to know that we will get to see you again soon in an upcoming meeting. And I appreciate you and your time today.
My pleasure. Always happy to help. Someone asked me to put my contact information, so I just put a link to our law firm's website, and you can find all of our and my contact information on there. But always happy to do this. I do a lot of speaking like this for particularly association execs of state and local associations who often don't either have the same resources as national organization and or access to experienced association legal counsel. So it's always very rewarding and gratifying to be able to do this, and happy to come back in the future if you guys would like. So thanks for your time today, and I'm going to say goodbye.
All right. Well, thank you, Jeff. Thank you, everyone, for being here. And we look forward to seeing you next month at our next Lunch and Learn. And it's going to be all about conventions and all the changes that